Hello, my name is Steve Benton with the Elder Financial Safety Center, and this is Money Smart for Older Adults, Episode 6, focusing upon end-of-life planning. To ensure your plans and your desires for your assets and for your heirs are clear and documented, or even for your own personal protection if necessary, this question is of critical importance to ask yourself. Are you properly prepared? This sign humorously tells a story very clearly. Failing to plan ahead has consequences. It was Ben Franklin who said, "By failing to prepare, you are preparing to fail." The truth is that your desires do not come to fruition without planning ahead. Just willy-nilly wishing and hoping things will go as the way you want does absolutely no good. Estate planning. If you're like me, you hear the word estate, you think about that big house up on the hill with big white columns in front. But in actuality, every one of us has an estate. Estate planning is an all-encompassing, sophisticated term used by attorneys, tax planners, certified financial planning people that basically says you get to call your own shots. It's answering the question you see here: how do you want your money, your property, and physical body to be managed during life and after death? In other words, what's the plan, Stan? While alive, getting help when you need it, if necessary, that your desires and your directives are followed, and then at death, again, that your decisions, that your directives are followed. Let your wishes and desires be known. Are they memorialized in documents and on all your financial accounts? Or are they just in your head? There are two primary types of documents that add legal force to your wishes: a will and powers of attorney. A will, as you see on this slide, are instructions to be followed after your death. The legal force of a probate court and a judge are there to ensure that your documented wishes, your desires, are followed after your death. The powers of attorney, as you see, are appointing agents to make decisions for you when you need help while you're still alive. So again, it's to give legal power to a person you trust to make decisions on your behalf when you cannot while you're still alive. So these two types of documents never operate simultaneously. The power of attorney authorities that you granted cease upon your death. And likewise, the will has no authority while you're still alive, but only after death, and when presented to the court to validate and grant authority to those you have appointed. Some basic terminology to understand: dying intestate simply means you died without a will. Does not mean the state gets your money, even though the word sounds like that, but you're leaving it up to state law and others to make decisions that you could have made differently and by yourself. The executor or administrator is who you name in your will to be responsible to carry out your stated wishes and desires. The probate judge gives authority to that person to manage and distribute the estate that you left behind according to your instructions, and holds that person legally responsible. You might hear someone say, avoid probate if at all possible, like probate is some sort of a disease that you need to avoid. It might be that way in California, where people line up around the courthouse to get before a judge, and it is very, very expensive. But probate is simply a protective process with some costs involved. Certain steps can be taken to reduce the size of an estate and thereby reduce costs of probate or avoid the need for probate whatsoever. Payable upon death, in other words, naming beneficiaries on your bank accounts, your brokerage accounts, and other financial accounts, actually redirects that money outside of probate. So these financial institutions do exactly what you instructed them to do upon notification of your death. They pass those assets on to the people that you named in their documents. So that reduces the size of your estate. Now you can do that on real property, your house, your land. You can do a transfer on death deed and file it with the county clerk, and he will do the same process of transferring per your instructions. More sophisticated estates, you'll find attorneys recommend ladybird deed trusts, but for the simple, non-complex, straightforward estates, These are very effective strategies, and they are revocable. In other words, you can change your mind. Suppose one of your children goes off the family reservation, doesn't want to have anything to do with you anymore. You can simply revoke what you filed and file a different document. Do you have beneficiaries named on your financial accounts that match up to your will? Remember, payable upon death and transfer on death deeds, ladybird deeds, these tools trump a will. I like this slide because this was my high school car, 63 Chevrolet Impala. I wish I still had it today. Cars, boats, you can pass title upon death outside of probate. One realizes the importance of planning ahead when considering these stats. 1 in 10 of 65 years and older, 1 in 3 at 85 plus, have cognitive challenges, have experienced cognitive difficulties, and as they emerge, you become an easy target for theft and scams and frauds because you are targeted. 70% of all assets in this country are owned by those that are 50 plus years old. That's baby boomers and above. Documents and protections need to be in place. Who have you arranged to be there for you when these challenges might arise? Due to the dramatic increase in frauds and scams perpetrated on the vulnerable senior population, banks, brokerage firms, and other financial providers now suggest that you add trusted contacts to your accounts to whom you grant permission to be contacted if you start exhibiting abnormal behavior in your financial life, like wiring funds overseas in these prevalent romance scams today, or supposed lottery wins. There's sob stories out there from con artists playing on your willingness to listen, but losing your ability to discern properly. These trusted contacts you name have no authority in that account. They cannot view or transact any business, but are simply informed that the financial provider has noted significant change in your behavior or in your documents and suggest that the trusted contact find out what is going on in that person's life. Powers of attorney, sword or shield. They can protect you, but also stab you in the heart if that trusted individual you have empowered puts their interest ahead of yours, abusing your trust. A power of attorney is a legal document where you give legal authority to another person to make decisions for you and to act on your behalf. 60% of the issues brought before the Elder Financial Safety Center involve abuse of financial powers of attorney, financial abuse. Moms in memory care, daughter or son has the power of attorney and out spending her money. Financial abuse by known individuals, 90% of it comes from family, friends, and caregivers. Because you are giving carte blanche power to another person, it's easy to see how this can be used as a shield to protect you against a complete financial catastrophe, or it can become a sword used against you, most commonly for the other person's financial gain. For that reason, when you consider who will be your power of attorney, it is important that you select someone you trust implicitly. There are basically two types of powers of attorney. First of all, the medical power of attorney, as you see here, you give authority to someone to make medical decisions for you when you are incapable. Maybe you lack the mental capacity to make your own decisions. And you'll see there the footnote, not to be confused with advanced medical directives, sometimes called a living will. And these would include things like a do not resuscitate order and so forth. And then there's the general durable power of attorney that involves money. You give authority to a trusted agent to transact financial business on your behalf, limited or unlimited. There's the story of the childless man who is facing some surgery and rehab, a long 3-month process, and his big concern was who was going to pay his bills, his utilities and so forth, watch over his house, and who was going to feed his dog while he was out. So he got his nephew and he gave them a full, unlimited general durable power of attorney. When he emerged 3 months later, All of his money was gone, all of his house and property had been sold, and the dog was nowhere to be found. So you can see the dangers that you have in the trusted individual that you give this unlimited power to. When working with an attorney, typically a package of all these documents, the will, the power of attorney, the medical directives, is produced. And let's remind you that all of these power of attorneys and any directives that you've made are all revocable. While you're still alive, you can change your mind. It is amazing how much money is sitting at the state waiting for someone to claim it. This is a process called escheatment. The state does not want your unclaimed assets, but they do require companies not to hold on to that money, but forward it to the state so that they can find the proper owner. That's why you see the names printed occasionally in the newspaper and also on the website. All of our clients at the Elder Financial Safety Center, we put through this filter, and we have about a 20% hit rate of finding money for these individuals. Now, it may not be much. It may be deposits, maybe $25, $50 here and there, but money is money. Seniors notoriously forget about certain assets as they age, and so it's a simple process. Attorney not needed unless it's an estate issue, and make sure you're on the state's website when you're searching. It's easy claim form. I recommend that you have the conversation. Having the family conversation of what your wishes and your desires are as you approach end of life and the plans you have in place. It's an excellent tool. It's available at the website listed. We encourage you to set aside an hour or so with your loved ones. They will know you have your house in order and that they are understanding of your wishes. This slide speaks for itself. Biggest enemy of estate planning, procrastination. Don't be a sloth. If you need more information, contact the Elder Financial Safety Center by telephone, email, or by visiting our website. Thank you very much.